I welcome you all to this guest lecture of the Global South Network guest lecture series. I'm Dr. Nauman Rayat, convener of Global South Network. My research interests lie within the area of constitutional law and politics in the Global South. I founded Global South Network on 17th of March 2023. Ever since then, in my capacity as the convener of this network, I organized 29 events, involved 51 postgraduate researchers from or focusing on the Global South, engaged with 7 constitutional courts of different Global South countries, including but not limited to Pakistan, Afghanistan, South Africa, Maldives, Nigeria. Received 3 internal fundings from ESRC International Impact Acceleration Account and built 3 international partnerships. Staff and students from 10 disciplines, 4 civil society organizations, 28 universities, and 15 countries participated in these activities. I secured 2 book contracts, one from Springer and the other from Routledge, focusing on constitutional law and politics and judicial independence in transitional democracies. The details on initiatives, aims, objectives, outreach, and activities of the network are available on globalsouthnetwork.com. The website is being updated on daily basis. Some of the data has been uploaded. The rest of the data we are uploading, subject to the data protection and data management policies. Today's first lecture will last for around 1 hour, followed by 30 minutes question and answer session. Restroom is situated at the right. When you go out at the right of the hallway. In case of fire, gathering point is situated outside the building. You can use stairs. Stairs are on the left. Now allow me to introduce our honorable guest for today's guest lecture, Justice Stephen Arnold Majiedt, who is a current Justice of the Constitutional Court of the Republic of South Africa. He was appointed in 2019, leaving his seat at the Supreme Court of Appeal, where he was first appointed in 2010. Prior to this, Justice Majiedt was an advocate at the North Cape Society of Advocates, before his first judicial appointment at the North Cape High Court in Kimberley in 2000. Over to you on this.
Thank you, Norman. Good afternoon, everybody. It's a pleasure to be here, and especially to be invited by the Global South Network, which I think is a wonderful, wonderful initiative, Norman. Congratulations and well done to you. And I'm going to speak about the South African Constitution, and of course, I understand that not all of you would be au fait with its provisions, but I'm going to try and keep it as simple as possible. And there will be an article published afterwards, and so it will be accessible on the Global South Network platform. It's widely recognized that our country is one of the most progressive constitutions in the world. Some say it's too progressive, given the fact that we're an emerging democracy and a third world country. Be that as it may, one of the founding values of our constitution is a commitment to the rule of law. And because of our history of apartheid, which in English means separateness, we also have founding values of freedom, dignity, equality, and accountability. It's understandable that these would be the pillars on which a country who is ravaged by separateness, by subjugation based on race, would have those as founding values. Some academics have described our constitution as a bridge away from a culture of authoritarianism under apartheid to a culture of justification, a culture in which every exercise of power is expected to be justified. And so one of the central pillars is the doctrine of legality. All institutions, organs of state, including the courts, only have the powers ascribed to them under law and no more. And under the law, I mean the supreme law, the Constitution, and all other acts of Parliament and subsidiary legislation. South Africa had 2 constitutions, an interim constitution in 1993, and then the permanent final constitution, which is our present constitution. We call it final Of course, nothing is final as far as law is concerned, but to distinguish it from the interim constitution, that is the 1996 constitution now. In the epilogue of our 93 interim constitution, that document is described as, I quote, a historic bridge between the past of a deeply divided society characterized by strife, conflict, untold suffering and injustice, and a future founded on the recognition of human rights, democracy, and peaceful coexistence and development opportunities for all South Africans, irrespective of color, race, class, belief, or sex, close quote. We all see our constitution as a transformative constitution. We must transform from what had been in the past to what we would like to see as a more egalitarian and just society based on those founding values encapsulated in the constitution, which I've alluded to. And we accept that this is a journey. It's not an event. And we abolished the death penalty in one of the court's early judgments, State versus Mkwanyane. In that case, the death penalty was outlawed as inhumane and degrading punishment. And it's the only case, the first and the only case thus far, where all 11 judges of the court, all 11 justices, wrote a separate judgment because of its importance. Because you see, under apartheid, the death penalty was weaponized. And many young armed struggle guerrillas of the ANC and Patla, which the regime called terrorists, were hanged, some as young as 20 and 21 years old. And in that case, the court said, it was Justice Mohammed who later became the Chief Justice. In some countries, I'm quoting from that case because it's such an important case. In some countries, the constitution only formalizes in a legal instrument a historical consensus of values and aspirations evolved incrementally from a stable and unbroken past to accommodate the needs of the future. The South African constitution is different. It retains from the past only what is defensible and represents a decisive break from and a ringing rejection of that part of the past which is disgracefully racist, authoritarian, insular, and repressive, and a vigorous identification of and commitment to a democratic, universalistic, caring, and aspirationally egalitarian ethos expressly articulated in the Constitution. Now, we've come a long way since the adoption of the Constitution, and as I've said, it's a journey. It's been a very arduous one, and it is replete with complexities and challenges. We've overcome apartheid, but the promise of a democratic South Africa based on egalitarianism and one in which human rights, freedoms, and human dignity has been advanced remains a huge challenge and is the subject of much debate. That is particularly true in those rights that affect our people most directly on a day-to-day basis, the socioeconomic rights. And we've got partially a limited justiciable socioeconomic rights like education, housing, and now that's a very complex topic which I've been speaking about for the last week or so since my visit to the UK, but I leave that for another day. Our country is in the midst of turbulent times. Under Mr. Mandela, we were the darling of the world because we were seen as this rainbow nation, very diverse but unified in our diversity. And Mr. Mandela and his cohort of the first cabinet, and he only stayed for 5 years. He could have stayed another 5 years in terms of the constitution, but he stepped down. That first cabinet, that first leadership was exemplary in leading by example. But today we are racked by rampant corruption, pervasive incompetence, and there's a marked inertia on the part of both the executive and the legislature, and also the bureaucrats. We've lost our global stature as a model democracy. And the challenges that we face today, colleagues, affect all facets of the lives of ordinary people. There's been a rapid and ongoing decline in the delivery of basic services. and we are faced with widespread sporadic civil protest. Next year, there will be general elections exactly 30 years after the first democratic elections in 1994. And many are saying these are landmark elections. The first elections in 1994 were important to establish the democracy, and many say next year's elections will be a test of whether this democracy survives and endures. And so the contestation is high, and everybody is looking to see what's going to happen. Now let me move on before I come to what I want to discuss with you. And my topic is judicial independence and judicial activism in the face of transformative constitutionalism and legislative and executive inertia and incapacity. I'll deal with that topic in a few cases. But what I want to say is that it's become very worrying that both the executive and the legislature have fallen short of what the public expect from them to execute their constitutional mandates. Because for all the rights in the Constitution, there are concomitant constitutional duties and obligations placed on the state in its various arms. The executive must make policy and execute it. The legislature must pass the laws that come by way of policy to it, a green paper, a white paper, and then a bill. And of course, the judiciary, the courts, must see to it that everything happens within the parameter of our constitutional dispensation. And our court, the Constitutional Court, is the highest court in the country, and we're the ultimate guardian of the Constitution. And so when arms of government, the executive and the legislature, fail in their constitutional obligations, to the extent that people feel in a very real way every day in their lives, in education, in the streets, in municipal services or lack thereof, in health and in housing, more pressure is placed on the third arm of government, which is the judiciary. And our judiciary is still held in high esteem, not only domestically, but also around the world, I gather, as I travel. And judges are trusted, and our court in particular is seen to be a very trustworthy court, because I think our jurisprudence has shown thus far that we've given orders and written judgments without fear or favor, as the Constitution demands. But there's only so much that judges can do. There is only so much that courts can do, because no power is unbounded. And our Constitution places firm contours on the outer bounds of our powers, even as the highest court, the Constitutional Court, which has extraordinary wide powers. Now, there are two aspects that I must briefly deal with before I come to the cases, which are constraints on our power. I've said so in terms of the Constitution, but it's the separation of powers and the doctrine of legality. We are fiercely independent as judges in South Africa. In fact, too independent for the politicians. The governing party now claim that we in South Africa, especially the apex court, the Constitutional Court, are unelected and want to govern the country. That is not so. We are an essential check and balance in terms of the separation of powers on the unbridled powers of the executive in particular, but also the legislature. It's a very difficult tightrope that we have to walk. We have to assert our judicial independence and ensure that the Constitution is complied with at all levels, up until the president, without straying into the domain of the legislature and the executive, because that would be in breach of the separation of powers principle, the res politica as we know it. Many say, of course, that the res politica, the separation of powers, is in itself part of the institutional support structure of judicial independence. And I think that's right. Judicial independence means that you must be independent, but stay in your lane. Do not assume powers that the Constitution has not given to you. It is so that we act not only as a check and balance, but as a bulwark against authoritarianism. And authoritarianism is what typified the apartheid state. It was a brutal regime, authoritarian, and the rule of law was nowhere to be found. Of course, parliamentary sovereignty meant that courts could do no more than inquire into whether Parliament has done what it had to do, and once Parliament had passed the law, however repressive it may have been, correctly, in terms of procedure, that was it. In a case that we decided quite early in the court's life, the Constitutional Court in Minister of Public Works versus Kailami Ridge Environmental Association provided an exposition of what this doctrine of separation of powers is all about. That case concerned a township development of a neighborhood, and certain environmental objections to it. And there the Constitutional Court said that the separation of powers prescribed by the Constitution is not absolute, and on occasion some overlapping of functions is permissible, and action that is inconsistent with the separation demanded would however be invalid. And so our Constitution doesn't have a model of what separation of powers should look like, but it is one of partial separation. There are two cases that the court decided early on socioeconomic rights. The one was Grootboom, which in English means big tree, and it concerned a woman, Mrs. Irene Grootboom, who lived in an area in the northern part of the Cape Peninsula, and my wife and I lived in that area, Wallisdean, where this informal settlement was situated. And it concerned emergency housing. And they went to court urgently to the High Court in Cape Town, and they got a limited order and appealed directly to the Constitutional Court. And the court said the emergency housing plan of the city of Cape Town, was inadequate, but the court didn't interfere by rewriting the policy. It was early days yet. And the court said, this is an area for another arm of government, and they sent the housing plan back to the city and said, improve your plan so that it can make provision for these poor people who were living under the most squalid of conditions. And they did, and the court eventually was satisfied. The other case was Subramani. That came from a city on the east coast of South Africa, Durban. And that concerned Mr. Subramani suffered severe renal failure, and he required dialysis. But he wanted an order that he gets special dialysis on a daily basis. And the court refused to grant that order because the court said, must look at what is available as resources for everybody. Because if Mr. Subramani was to succeed and to get his special dialysis, the others would not be able to be treated, the other patients that required routine dialysis. Now, Mrs. Grootboom, who was the first of these 5,000 applicants in that housing case, died without ever getting a house. Mr. Subramani died because of kidney failure because he didn't get the dialysis. Many critics point to this to say that the Constitutional Court has failed in those early cases. But, and I'm not defending the court, I think one must understand that as a judge, you come from a system of colonialism for centuries and of apartheid for many decades. And there's a huge mountain to climb to overcome the institutionalized backlogs deliberately created by apartheid, by the separate development policy. And you can't just wave a wand and call the Constitution and say, everybody is now going to get these rights fulfilled. And that is why our Constitution talk of a progressive realization of the rights. So it's a partial, limited justiciability, and it speaks of within available reasonable resources. So that was the history of the court in the early days. When I talk about the separation of powers, it means that judges must defer to other arms of government. We can't rewrite budgets. Budgets is a very intricate, involved process where subcomponents feed into a component, into a department, feed into other sub-units in the department, and eventually it comes together. And it's a long, very involved technical process. We don't rewrite budgets. We don't award tenders where we find them to fall short of the legal standard. We don't appoint people where they should have been appointed, and we set aside invalid appointments. That is for government, the other arms to do. But it doesn't mean because we show judicial deference that we are judicially timid. I think that the jurisprudence of the Constitutional Court ringingly shows that we have been far from timid. In fact, when you listen to the politicians, as I've said before, they say we are too active. We are exerting too much power so that it looks like we want to govern. Just as an aside, many academics and non-governmental organizations, and we've got very active non-governmental organizations which really ensure that the poorest of the poor do get their cases to court. And they're doing excellent work. So many of them and the academics say, well, the court is moving too slowly. All the courts, but particularly the Constitutional Court. As I said to you early, in Grootboom and Supramoni, the court sent the matters back and didn't grant the relief. And so I always say somewhat cynically and almost facetiously, we must be doing something right if the one party is saying we're moving too fast and the other one saying we're moving too slow. Maybe our pace is just exactly right. But it's a journey. Jurisprudence in a new constitutional dispensation must be allowed to develop. I'm now going to refer you to a few cases where Parliament had failed in their duties, constitutional duties, and one or two cases where the President has failed in his constitutional obligations and how we've dealt with it. Can I just check, Naman, how am I doing for time? I'm always worried about
Time. In 20 minutes.
Thank you. And I'm just about halfway. We recently had a case where an extension, let me just explain how it works. We, in terms of the Constitution, will consider a case and decide whether the relief sought should be granted that a provision in an act of Parliament, for example, is unconstitutional. If we find that section or sections or subsections to be constitutionally invalid, which happen quite frequently, for some other reason, we will make that order and we will suspend that order for 2 or 3 years, remit the matter to Parliament with an instruction to remedy what is wrong as per the judgment and the order, and in the interim make an interim order that the provision, the impugned provision, will read X, Y, Z until Parliament has rectified, has passed remedial legislation. Parliament doesn't do it before the deadline, that interim order becomes final. When we do that, technically speaking, strictly technically speaking, we are intruding in another domain of government, in the domain of another arm of government, sorry, the legislature, because we're really legislating. But that is one by high exception, and the Constitution does allow us to do that. So that is the procedure. Recently, Parliament sought, not for the first time, not for the second time, but for a third time, an extension of a deadline imposed by the court to finalize remedial legislation. Now remember, Parliament must get the act together within the 2 or 3 years, depending on what the order says, and amend the legislation, failing which the order that the court has kicked in will no longer be interim but be final, and it must come back to the court, even on an urgent basis, to seek an extension of the deadline. In this case, they sought it not once, not twice, but it's the third time. And this was the case about election law. Speaker of the National Assembly versus New Nation Movement. Now, this case concerned the fact that, just very, very briefly and simply put, our Constitution doesn't allow anyone to stand for public office, and by that I mean as a member of Parliament, or to become president if you're an independent candidate. You can only do so through a political party. And in this judgment, we simply call it New Nation Movement. In June 2020, the court had declared the section in the Electoral Act unconstitutional because it says that people may only be elected to the National Assembly and to provincial legislatures through membership of political parties. Parliament was given time to remedy. They didn't do so. They sought a first extension, second extension, and eventually in December 2022, they came for a third extension. And the legislation was eventually passed after we've given them their third extension in February of this year. Now, just in case you're wondering, I'm presently on long leave on a sabbatical. That's why I'm here. But I was part of that case of the judgment. And in that judgment, we made it very clear that granting an extension is just it's not just there for the asking. The predominant consideration is the interest of justice. And we noted that it was very important for our democracy that Parliament's tardiness and failure be tolerated just this once, because it was just and equitable and in the interest of justice that this be expanded to independent candidates. Mind you, in my absence, the case started while I was still there, but since I've been away from the court in the month of August, this New Nation movement and other parties brought 2 cases to the court again directly because of the urgency, because we have national elections last year, as I've said earlier. And the case there concerns the fact that they say this amended electoral act is unconstitutional because it sets a higher threshold for independent candidates than it sets for candidates from political parties. It's all got to do with the fact, and it's very technical, they had a lot of technical experts. I read some of the papers, not all of it because I was on leave. But it concerns the fact that our constitution makes provision for a proportional system of government. The court considered there then that it was just and equitable that the extension should be granted, and the act has now been amended, but there's 2 more challenges to it to hold together. In an earlier judgment called Mhlope, which concerned the addresses of eligible voters on the national common voters roll, was also ruled invalid, and the court there considered what the factors are that it must take into account before it considers granting an extension. And in this New Nation movement case, our court referred extensively to it. Now I've referred very briefly to Mhlope, and you'll see these cases in more detail once the article is posted, hopefully next week, not next year. Sorry, Norman, I could see you glaring at me next week. Out of the press, the third and the last case as far as parliamentary laxity is concerned, the judgment that was delivered this morning. So it's hot off the press. It's a judgment I wrote. The judgment was unanimous, and it was handed down by one of my colleagues in Johannesburg this morning. It's a case called Minister of Home Affairs versus Lawyers for Human Rights. Now, Lawyers for Human Rights is one of the NGOs that litigate extensively and actually very ably in these kind of cases. The case concerned our Immigration Act, sections 34(1)(b) and D. And that act, those sections had been declared unconstitutional by our court in 2017. That was before I joined the court. I joined the court in 2019. And Parliament, it basically concerned the fact that when you come into the country and use refugee status, there's an interim procedure, and that interim procedure didn't make provision for you to be heard and to be represented by a lawyer and so on. But the court, the details aren't that important. Our court gave Parliament 24 months, that is until June 2019, to correct the defect, and interim relief was granted, as I've said, as to how the sections are deemed to read. But Parliament failed to meet that 2019 deadline. Lo and behold, the Minister of the department, who is the political head, and the Director General, who is the most senior bureaucrat in that department, approached our court in July last year on an ex parte basis by way of an urgent direct access application for what they called a revival of the 2017 order. Now, because the 2017 order had lapsed in 2019, these cases end up before magistrates, which is the lowest part of our court system. And there's a lot of confusion at reigned. Many magistrates said, well, the order is pro non scripto, it doesn't exist anymore because Parliament didn't do anything to amend it. Others refused to hear such cases. Others just released these immigrants who had been arrested and were to appear in court pending their applications, and then would have been released if the magistrate was satisfied. They refused to hear these cases. Others just released them, and there was an absolute confusion. But then they came back the Minister and the Director General last year and sought an order that this 2017 order be revived. And what they'd also done is, while that order was pending, they went on an urgent basis to the High Court and sought an order from the High Court that that order of 2017 be revived pending the Constitutional Court decision. Now, I don't think you have to understand our system to know that the High Court has no power whatsoever to suspend any decision of the highest court, because our hierarchy is the Magistrates Court, the High Court, the Appeal Court, and then the Constitutional Court. But what was worse was that the Minister and the Director General, obviously relying on legal advice, did not join the original applicant, Lawyers for Human Rights, as a party to the proceedings. They brought it ex parte without notice. It was just unbelievable. It was shocking. And there were four, not one, not two, not three, but there were four decisions of our court that said once an order has lapsed and Parliament hasn't done their job and they haven't sought an extension, the order could not be revived. And they had two advocates, barristers, as you would call it in the UK, a senior advocate of long-standing, 20, 30 years as a SOG, and they had two juniors, if I can remember correctly. They didn't draw the High Court's attention or the Constitutional Court's attention, our attention to these four cases, but we knew about the cases. And so it was either gross negligence or it was a deliberate concealment or attempted concealment of these cases. And so we took a very dumb view of the conduct in this case. And what we did was, although the order had lapsed, our powers are so extensive that we had to make a just and equitable order, as the Constitution says in Section 172 we may do, just to regulate the position of these poor detainees who had nowhere to go, and some of them may be worthy candidates for refugee status. And so we regulated by making an extensive interim order, which is not really what I want to discuss. I want to say to you that to show our dissatisfaction with the conduct of the Minister and the Director General and their lawyers, we made an extensive cost order. And it's a cost order which I understand from the feedback back home has really had people sit up and notice. Because for a long time now, what government does, when I say government, I mean the bureaucrats and the political heads at all levels, at national level, but also in the provinces. They litigate and they litigate and they litigate, and the taxpayers have to pay because they're not litigating out of their own pockets. And so what we did in this case, we ordered the Minister of Home Affairs to pay 10% of the costs, which we ordered against them in favor of Lawyers for Human Rights out of his own pocket. And we ordered the Director General to pay 25% of the cost out of his own pocket. Moreover, because we accepted, and the Minister said so, we wrote to them and said, or the Chief Justice wrote via the Registrar of the Court and said, can you show cause why these personal cost orders should not be made and why the lawyer shouldn't be deprived of their fees? And they came back with a whole hullabaloo, and it was actually shocking. The Minister said, you know, the Director General says in his affidavit, I'm authorized, I make this affidavit in opposition to this application or in support of this application, because they were the applicants, both on my own behalf and on behalf of the Minister, duly authorized. The Minister comes back when we asked him to pay about the costs. He says, well, I don't know anything about this case. I've never authorized the Director General. And the Minister and the Director General also said we acted on legal advice. So we ordered 10% for the Minister, 25% for the Director General, and we deprived the lawyers of all their fees. We said you're not entitled to charge any fees because of all the things they've done wrong in the case. And so I think that's going to make people sit up and notice, because for too long people are litigating carelessly and recklessly at taxpayers' expense. Let me hasten to talk about two cases where the President had failed. In fact, I think I'll just mention one. And it's the infamous Nkandla case. The former President of the Republic, President Zuma, who later was to be sentenced to jail in a matter in which we, as the Constitutional Court, found that he was in contempt because he disobeyed an order of ours to go and testify before the Anti-Corruption Commission, known as the Zondo Commission. And President Zuma has a large homestead, a large private home in the area of KwaZulu-Natal on the east coast in the inland, and known as Nkandla. It's a large homestead with several homes. That's his private residence. But a president, a sitting president, is entitled to security at his or her home, even private homes. And extensive repairs of millions of rands, hundreds of millions of rands were done there. And when two political parties laid complaints with the public protector, which is a Chapter 9 institution, the public protector found that a lot of that work, an extensive part of that work, was nothing to do with security, like swimming pools and so on and so on, and ordered the president, and they wanted the president to pay for it. Some relief was granted in the High Court. They came directly to us because only the Constitutional Court can declare conduct of the president invalid. So they came directly to our court, and the Constitutional Court held the president liable. And it said the president is the head of the state and the head of the national executive. His is the highest calling to the highest office in the land, and he's the first citizen of the country. Upon him is the primary constitutional duty to uphold and defend our constitution as South Africa's supreme law. And they found that he failed to do so and ordered him to pay for the non-security repairs. I think I'm nearing the end so as to allow enough time for questions. The Nkandla case is a landmark case because there the Constitutional Court held the highest citizen, the highest office in the land, constitutionally liable for a failure to comply with constitutional obligations. It shows that the extensive powers that our court has, and as I've said to you, that same former president was later sentenced to 15 months imprisonment for failure to appear before the commission as ordered by our court, and he was held to be in contempt. I want to conclude by saying, in our country, our courts are now under increasing pressure to stray beyond the constitutional bounds of our power. Why? Because the other two arms of government are seen to be failing spectacularly, the executive and the legislature. But however bad it may appear to us to be, where there's legislative or executive recalcitrance or inertia, we must tread carefully to make sure that we tread where the Constitution does not allow us to go. It's a very complex topic on its own, and I've spoken elsewhere about it. But let me just, at this juncture, say, our administrative law courts are entitled to make orders of substitution, which I understand the UK courts until recently did not have, or very reluctantly gave such orders. So normally, if you set aside a decision made by a decision maker, for example, to award a tender, he would send it back to the decision maker and say, go back to the subcommittees and look at the costing. Let's say it's a large civil construction project. Look at the costing and look at the scores, because they allocate points for certain scores. Not for us to award the tender. The same with an appointment irregularly made, and so on. And the rewriting of budgets. For example, in Grootboom, we weren't going to say to the city of Cape Town, go and rewrite your budget, or rewrite your housing policy plan. And in Subramani, we weren't going to say to the Department of Health, go and reconsider how much money you spend on dialysis, so that Mr. Subramani could be helped. So we rarely make orders of substitution, but in some instances we do. We would not remit a matter. There are several factors, but let me go to two of them, which are the key ones. So we will not remit a matter where it's a foregone, the outcome is a foregone conclusion. And secondly, we will not send the matter back to the original decision maker where all the facts are before the court. In other words, if those two factors are present, we would, on rare occasions, do substitutionary orders. Now, the reason why we do this so infrequently is exactly because of the separation of powers. And we are very conscious of it. I conclude my dear colleagues, by saying we in South Africa are experiencing now the pain of corruption, incompetence, and apathy. And that pain is acutely felt, particularly by the poor, marginalized, and the most vulnerable. We declare law or conduct invalid for failure to comply with the Constitution. We are given very wide powers to grant just and equitable relief, as it's called in Section 172. That's a very wide phrase. And the courts approach it very generously to say that we can give any order that is just and equitable, that is in the interest of justice. And Section 38 of our Constitution also says that in order to protect and enforce the Constitution, we must give effective relief, and was appropriate relief. Again, that's a very wide phrase. And so to end, let me say this. Despite all these wide powers, we must remain vigilant and diligent in fulfilling our high duty as guardians of the Constitution. We must act boldly and decisively as we have done, but we must be conscious of the fact that we are walking a tightrope, that we are not seen to stray into the domain of other areas of government. When things fall apart around you, people tend to come to the court and say, please help us, please redraw the budget, please allocate funds for housing, please allocate funds for health, and so on, for education. But we can't do that. We can only go back and say, government, show us what you've done over the last 30 years to progressively realize this right as the Constitution says, or show us your reasonable resources. But I suspect, just venturing an opinion as to the way forward, I suspect that the time will come when courts, especially our court, will say, if you say we don't have the resources for this education project to build the school, or to give stationery to the school, or to appoint teachers to the school, or to put in desks and chairs, we will say to you, Education Department, well, show us your budget. Let's see what you've been doing over the last 30 years. And if it's clear that there's been maladministration or even theft, corruption, court may well say, well, less of that and more of service delivery. And so I think the time will come when the court says, now 30 years down the line, let's see whether there's been progressive realization, and let's see what you've done with your resources. And so going forward, I can see the court playing a more active role, but only within the bounds of the Constitution. We can't do more than that, although our people, I think, would like us to do more. Thank you. Thank you, Norman.